BYJU'S Exam Prep brings to you the second All India Open Mock Test from 21st of October to 31st of October. Go ahead and register now in the BYJU'S Exam Prep app and compete against thousands of aspirants.
A very, very good evening to all of you, friends. A very, very good evening to all of you. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. So, friends, since you guys are preparing for CLAT 2023 and you just have a couple of days left, couple of weeks. 18th of December is your examination. So since you guys are preparing for this examination, which is scheduled to happen within a couple of weeks' time, how is your preparation going? Now, apart from the preparation that you are having, it is absolutely important that you sit and do the mock tests. Mock test will play a very, very important and crucial role insofar as the preparation for this entrance examination is concerned. So BYJU'S Exam Prep brings to you the All India Open Mock for CLAT 2023, which is live between 21st of October and 31st of October. Today is the 31st of October, the last day for you to appear for this All India Open Mock for CLAT 2023. I want each and every one of you preparing for CLAT 2023 to sit and appear for this mock test. Why? Because this is going to help you to understand the kind of questions that you might probably get in your examination. This will give you an idea about your strength and your weaknesses. And a student who is appearing for CLAT must be aware of his strength and weaknesses before the examination. It will give you a real life idea how to appear for this examination. So I want each and every one of you to sit for this mock test. Today is the last day. Those of you who haven't, please do it today itself. Now, coming back to today's session. Today, I'm going to discuss with you certain very, very important legal developments that have taken place in India. Now, as we are all aware of, this weekly legal current affairs for the October part 4, we are going to discuss about some very, very important crucial judgments that have been delivered by the courts. Now, why is it important? It is important because it will enlighten a student to understand what he or she should be preparing for. You must have a good idea about these things that are being discussed in the class, because we are going to discuss with you some important legal judgments, some legal developments. So guys, let's begin with this session. In this session, I'm going to discuss with you a couple of judgments. Shaheen Abdullah versus Union of India, Manoj Kumar Tiwari versus Manish Sisodia, INRE policy strategy for grant of bail. And finally, I'm also going to talk about State of Manipur versus Abdul Hanan. Now, these are the 4 important judgments that I shall be discussing in the course of this session. So before we start this session, I would request all of you to like the session and press the bell icon, and do not forget to subscribe to this beautiful YouTube channel dedicated for you guys. So guys, let's begin. Now, the first important judgment that we are going to talk about deals with certain very important aspects. And what are those aspects? I'm going to talk about all these 4 judgments. I'm going to explain to you these judgments in a very detailed manner so that if you get a question from any of these 4, you will be 100% sure that how to answer these questions. But before that, BYJU'S Exam Prep brings to you ACE, CLAT and other law exam with BYJU'S Exam Prep test series. So BYJU'S Exam Prep brings to you the Exam Prep test series, which provides 45 mocks covering all entrance examination. There will be 20 CLAT mock and 25 non-CLAT mock test. There will be 9,000 plus practice questions, topic test covering every single subtopic, 3 All India mega mock with video solutions by CLAT experts, detailed mock analysis. These test series are curated by NLU alumni themselves, and this tests are based on the actual exam pattern. So definitely do prepare for your All India mega mock and definitely do get your mock test. Okay, now, so guys, let's begin. The first one is Shaheen Abdullah versus Union of India. Now, over the years, over the last couple of years, we have seen in India a number of hate speeches. Okay. Now, what do you mean by hate speech? Hate speech refers to those kind of speeches which are given by people, including politicians, journalists, and other sectors of the media, as well as individual citizens, whereby there is a kind of hate that is generated against one particular community or 2 particular community. Now, hate speech is given by people who has some influence in the society. They can be politicians, they can be leaders, they can be journalists, they can be people from the media. Now, there is a growing feeling that there is a huge amount of hate speech in our country. Now, there is definitely a freedom of speech and expression. ठीक है, हम लोगों के संविधान में जरूरी एक चीज है कि there is a freedom of speech and expression. Now, freedom of speech and expression जो आपका आर्टिकल 19 में दिया गया है, उसका मतलब ये नहीं कि आप हेट स्पीच करें. There are certain amount of reasonable restriction which are imposed on your freedom of speech and expression, right? तो आपके पास freedom of speech है, but इसका मतलब ये नहीं कि आपका जो freedom दिया गया है आर्टिकल 19 के अंदर, वो आप कुछ गलत वे में इस्तेमाल करते हैं. Now, of late, there is a growing medians of targeting and terrorizing the Muslim community in India. So there was a petition that was filed, there was a particular petition that was filed in the Supreme Court seeking a direction to initiate an investigation, an independent, credible and impartial investigation into incidents of hate crime. आपको तो पता ही होगा, कुछ जगह में, कुछ धर्म संसद में, या कोई पॉलिटिकल लीडर या कोई मीडिया के लोग वेरियस टाइप्स ऑफ हेट स्पीच देते आते हैं आजकल. Now, that is not protected under Article 19 of the Constitution. Article 19 does not protect a hate speech being given by some individual. Now, of late, in the media, in the newspaper, wherever we go, we see a huge amount of hate speech which is targeting the Muslim community in particular. So, a petition was filed seeking an investigation, an independent, credible, impartial investigation into these hate crimes and hate speeches. Now, what did the Supreme Court say? The Supreme Court has invoked the constitutional mandate of fraternity and secularism. हम लोग के जो संविधान है वो कहते हैं यूनिवर्सल ब्रदरहुड, fraternity, we are all brothers and sisters. It also talk about secularism. There is, you might be Hindu, someone might be Muslim, someone might be Christian, doesn't matter to the government of India. From the eyes of, from the prism of the government of India, everyone is their children of the country. Now, fraternity and secularism are the basic ethos of the Indian Constitution. The moment there is any kind of a hate speech that violates the concept of fraternity and secularism which is enshrined under the Indian Constitution. The Supreme Court said that if there is hate speech in the country and the police does not act, the executive, the police is required to act. If they do not act, then the Supreme Court will initiate contempt proceeding against those who are responsible for initiation of some curbs. तो जो लोग देश के लॉ एंड ऑर्डर को देखते हैं, अगर उन लोगों के पास ऐसे कोई इंफॉर्मेशन आता है कि किसी बंदे ने हेट स्पीच दिया है और उसके अगेंस्ट में कोई कार्रवाई नहीं होता है, तो सुप्रीम कोर्ट विल इनिशिएट कंटेम्प्ट प्रोसीडिंग्स अगेंस्ट देम. The Supreme Court said that the apex court is charged with the duty to protect the fundamental rights and preserve the constitutional values of a secular democratic character of the nation. Now, the moment people say or gives a hate speech and nothing is done against them, they get encouragement. Now, कोई लीडर, कोई इंसान, कोई मीडिया के लोग अगर किसी भी प्रकार का हेट स्पीच देते हैं, it is the duty of the executive, that is the police officials, to initiate action against them. If they do not act against them, it shows to the people that those people in power are encouraging such hate speech. So did you understand what the Supreme Court tried to say? Any doubts? Any doubts? Sir, thought it's contempt. The executive takes time to probe. Yeah, the executive can take time to probe. But if they do not act, the moment you probe, that means you are acting on something. The moment you are investigating something, that means you are acting on something. Vinayak. So if after you have a knowledge that there is a hate speech being given at a particular place and the police is absolutely quiet about it, that should not happen. That will lead those police officers to contempt in the Supreme Court. Is that clear? Everybody? Am I clear? Everyone? Okay. Okay. Very good. So guys, if you're liking this session, do press the like button. If you're liking this session, do press the like button. Next. Manoj Kumar Tiwari versus Manish Sisodiya. Now the question in this particular case is very interesting. Whether a minister or a public servant can file a case of defamation. Now, there is this very important provision under the Code of Criminal Procedure, Section 199, which says and I would like everyone to pay your attention over here. Now, section 199 of CRPC says special procedure in case of the offense of defamation is alleged to have been committed against a person who is either the president, vice president, governor, administrator of union territory, ministers of union and states, and other public servants. Now, what is this special provision? Now, in case there is a situation where a person has made a defamatory statement either against the President of India, Vice President, ministers, governors, or other public servant, there is a special provision to deal with them. Now the question over here कि क्या एक मिनिस्टर को अगर मिस्टर ए एक मिनिस्टर है और उनको किसी ने डिफेमेशन किया है, क्या वो मिनिस्टर कोर्ट में जाके डिफेमेशन के केस फाइल कर सकते हैं? Now the Supreme Court in this particular case said that 199 says a court of session may take cognizance of such offense without the case being committed to it upon a complaint in writing by the public prosecutor or made by the public prosecutor with the previous sanction of the government. तो गवर्नमेंट के सैंक्शन के बिना अगर कोई भी डिफेमेटरी स्टेटमेंट आप प्रेसिडेंट के अगेंस्ट में बोलते हो या वाइस प्रेसिडेंट के अगेंस्ट में बोलते हो या गवर्नर के अगेंस्ट में बोलते हो या मिनिस्टर के अगेंस्ट में बोलते हो, वो इंसान डिफेमेशन सूट नहीं कर सकता विदाउट द सैंक्शन ऑफ द गवर्नमेंट. वेरी वेरी इंपॉर्टेंट. So the prior sanction of the government is absolutely necessary for the initiation of a defamation suit by either the president. So if someone abuses the president or defames the president can only go to the court and file a case with the previous sanction of the government. Now, what did the Supreme Court say? If a person belonging to a political party had challenged a person holding public office by stating, "I will expose your scam," the same does not amount to defamation. Because a defamatory statement, so in this particular case, जो बीजेपी का लीडर है, इन्होंने मिनिस्टर मनीष सिसोदिया को बोला है इन ट्विटर या कहीं पे कि आई विल एक्सपोज योर स्कैम. नाउ आई विल एक्सपोज योर स्कैम, डज इट अमाउंट टू डिफेमेशन? A defamatory statement has to be specific. It cannot be vague and general. The essential ingredients of defamation is that imputation made by the accused should have the potential to harm the reputation of the person. Now, just by stating that I am going to expose your scam, does it amount to defamation? The answer is no, it does not. So the Supreme Court in this particular case said, we understand that previous sanction is required, but the Supreme Court said that this law is a big question mark. Is it now? I have a right to sue a person if I have been defamed. Why can't the minister? Why can't the president of India? Why can't the governor? Why can't the vice president? They are also citizens of India. So there is this debate. You must know that yes, for the president to go to the court and file a case of defamation, previous sanction of the government is required. Okay. Moving on to the next important judgment. A very, very important and a crucial judgment that has come from the Supreme Court. A division bench which was presided by Justice Sanjay Kishan Kaul has laid down certain very important guidelines relating to disposal of cases, criminal cases through plea bargaining. This is a very important case, and the judgment, then the name of the judgment is In Re Political Policy Strategy for Grant of Bail. Now, over the years, what we have seen is there are huge amount of backlogs of cases, pendency of cases, huge pendency of cases. Cases are filed, criminal cases are filed against individuals, and individuals are behind the bar, behind the lockup. They are not granted bail, and this bail continues, and they remain in jail, and their pleas, the dispute is not decided by the court. So there is this huge pendency of criminal cases in the courts. Now, we all understand the importance of right to liberty. Now, the moment you are restricting a man's liberty, his right to life is violated. Now, it is absolutely important that criminal cases are disposed of as soon as possible, because the liberty of that individual is being restrained. So the Supreme Court has laid down certain guidelines relating to the disposal of criminal cases through plea bargaining. Now, what is plea bargaining? Now, in a civil case, if you want to settle your dispute, there is various other ways like arbitration, negotiation, mediation, conciliation. Similarly, in criminal law, there is this theory of plea bargaining. Plea bargaining. Now, what is plea bargaining? Whereby plea bargaining is a process whereby an alleged accused, an alleged person, okay, who has committed a criminal wrong, can say, okay, I agree that I have committed the wrong. I am ready and willing to pay some compensation and suffer X amount of jail. So by this, what happens? When you plea bargain, the disposal of the criminal cases becomes easy. The backloggings in the courts clears up. और दूसरी बात यह है कि liberty of that individual is protected. He walks out free. कुछ पैसा दे दिया, अदर साइड ने बोला ठीक है, आपने मेरे को मेरा सामान चोरी किया 10,000 रुपया का, आप मेरे को 20,000 रुपया जुर्माना दो. उसने बोला ठीक है, मैं 20,000 रुपया दे देता हूं, दे दिया, उसको जेल से मुक्त हो गया. तो दिस इज द वे, this is the beautiful way of plea bargaining. Now, in this particular case, the Supreme Court laid down certain guidelines. Some very important guidelines are, now the cases which are pending at pre-trial stage, evidence stage, where charge sheet is issued, where the offense, maximum offense, the punishment is 7 years. At a pre-trial stage, evidence stage, or a charge sheet stage. These are the three stages where plea bargaining can happen, provided the offense has the maximum sentence of 7 years imprisonment. Now, in this particular issue, the Supreme Court said that the accused as well as the complainant, both are entitled to legal aid by the Legal Services Authority. So we have the State Legal Services Authority, District Legal Services Authority, National Legal Services Authority, Supreme Court Legal Services Authority. So, District Legal Services Authority has a duty to provide legal aid to the citizens. So, an accused, a person who is accused of a particular offense, as well as the complainant, is entitled to get legal aid from the District Legal Services Authority. Thirdly, the Supreme Court said that only first-time offenders can do this particular thing. Now, if you are a habitual offender, किसी इंसान ने 10-10 चोरी किया है, उसके लिए नहीं है. जो फर्स्ट टाइम ऑफेंडर है, उन लोगों का केसेस विल बी टेकन अप. कोर्ट may also give, the Supreme Court said that the courts, executive magistrates, can also give time to the accused and complainant to think over the matter and give other dates, so that ये जो क्रिमिनल लॉ में हम लोग का जो इतना क्रिमिनल केसेस पेंडिंग है, इन लोगों को डिस्पोज ऑफ करने के लिए ये जो हम लोग का प्ली बार्गेनिंग का कॉन्सेप्ट है, दैट विल प्ले अ वेरी वेरी इंपॉर्टेंट एंड अ क्रूशियल रोल इन सॉल्विंग द मीनियंस ऑफ pendency in India. Is that clear, everyone? Is that clear, everyone? Okay. Before I move on to the next important judgment, I'm sure that it's not there in today's PPT on the slides. The Gujarat government has proposed a uniform civil code in Gujarat. Okay, it has not come on the ground, but they have said, the Gujarat government has said that, yes, they want to enforce a law that will provide uniform civil code in the state of Gujarat. Very, very important. Okay, moving on. The next important judgment, State of Manipur versus Bhumian Abdul Hanan. Now, when a person is arrested, जब कोई इंसान को अरेस्ट किया जाता है, उसके अगेंस्ट में क्या क्या एलिगेशन है, ये तो बोलना पड़ेगा उसको. So there is Article 22 of the Indian Constitution which says that every individual who is arrested has a right to know what are the charges against him. कल पुलिस आता है मेरे पास और बोलता है कि मेरे को आपको अरेस्ट करना है. क्यों भाई, क्यों करना है? Under which section are you arresting me? What are the allegations against me? I have a right to know. Now, in this particular case, what happened? Very interesting. Now, the police under the law is required to supply documents to the accused, documents which are relied by them. अगर मेरे अगेंस्ट में चोरी का इंजाम है, तो अगर कोई लेटर है, अगर कोई डॉक्यूमेंट है जो पुलिस रिलाई कर रहा है, मेरे को भी तो सप्लाई करना पड़ेगा. Now, in this particular case, wherein of the Manipur, which comes from the state of Manipur, what happened is that here was a individual who was not provided legible copies. ऐसे कुछ लिखा था जो दिखता तो है, कुछ डॉक्यूमेंट्स है, बट आप पढ़ नहीं सकते, जान नहीं सकते क्या क्या चीज है. Now, the supply of illegible or blurred copies of certain documents relied by the detaining authority amounts to violation of fundamental right. That is what the Supreme Court said. Right to make representation. Now, if I have to defend myself, अगर मेरे को कोर्ट में डिफेंड करना है against the allegations against me, मेरे पास तो कुछ तो डॉक्यूमेंट्स होगा। आप अगर मेरे को कुछ डॉक्यूमेंट्स देते हो, पुलिस अथॉरिटी अगर मेरे को कुछ डॉक्यूमेंट्स देता है और वो मैं पढ़ ही नहीं सकता, मेरा वकील साहब भी नहीं पढ़ सकता, कोई नहीं पढ़ सकता, तो मैं कैसे डिफेंस करूं? हाउ डू आई डिफेंड माई सेल्फ? हैव आई मेड माई सेल्फ क्लियर? इज दैट क्लियर टू ऑल ऑफ यू? So the Supreme Court said refusal to supply the documents requested by the détenu or supply of illegible or blurred copies of the documents relied upon by the detaining authority amounts to violation of Article 25 subclause 5. Article 25 subclause 5 says that when any person is detained in pursuance of an order made under the law providing for preventive detention, the authority making that order shall, as soon as may be, communicate to such person the grounds on which the order has been made, and shall afford him the earliest opportunity to make a representation against the order. Now, if you are providing blurred or illegible copies, अगर आपको आपके पास जो जो डॉक्यूमेंट्स आता है वो इलेजिबल है, वो ब्लर्ड है, तो आप कैसे आपका डिफेंस पेश करेंगे कोर्ट के सामने? डिड यू ऑल अंडरस्टैंड? सो दिस इज व्हाट द सुप्रीम कोर्ट हेल्ड in this case which comes from the state of Manipur. Is that clear? Everyone, am I clear to each and every one of you? Okay? Is that clear? So guys, if you are liking this session, do press the like button. Okay? Do press the like button. Okay? Okay. The Supreme Court said that it is well settled that right to make representation implies that the détenu should have all information that will enable him to make an effective representation. Refusal or to supply the documents, providing illegible or blurred copies amounts to violation of Article 22 subclause 5 of the Indian Constitution. That is what the Supreme Court held in this particular case. Am I clear to each and every one? Am I clear to each and every one of you? Is that clear? Is that clear? Okay, fantastic, fantastic. Okay, great. Yeah. Okay, brilliant. So, the Supreme Court also held that the right of personal liberty and individual freedom, which is probably the most cherished, is not in any manner arbitrarily to be taken away from him, even temporarily, without following the procedure prescribed by law. And once the détenu was able to satisfy while assailing the order of detention before the High Court in exercise of the jurisdiction under Article 226 of the Indian Constitution, holding that the grounds of detention could not satisfy the rigors of proof as a fundamental effect which has enabled him in making effective representation, the détenu's view that amounts to violation of Article 22 subclause 5. Is that clear? So guys, BYJU'S exam prep, before I say goodbye to all of you, BYJU'S exam prep brings to you an all India mega mock CLAT 2023, which is live between August 21st and 31st of October. Today is the last day. You have a couple of hours left. You have just a couple of hours left. So get the real CLAT experience, get to know your strength and your weakness, and identify your CLAT strategy by appearing for this All India Mega Mock CLAT 2023. By tonight 11:55, आज रात 12 बजे के पहले 11:55 तक आप ये मॉक टेस्ट दे सकते हैं. ओके. So guys, with this we come to the end of this session. Do subscribe and press the bell icon. Do follow us on our Instagram. Do like our Facebook page. Do join our Telegram channel. And do not forget to download the BYJU'S exam prep app. With this, we come to the end of this session. Thank you very, very much. God bless you. Stay home, stay safe, stay healthy. Bye-bye. Take care. Thank you. See you soon.